think it would have to be justified by the state. They may well come in with evidence that this is not a problem that needs to be addressed, and that the victims are more able to protect themselves. They may have
one step at a time. This is more common. This is or this is something that we find more odious.
Well, the one thing that I submit to you the state should not be able to come in to say is we are going to permit ourselves, the majority of people in our society, full and free reign to make these decisions for ourselves, but this one minority of people don't get that decision, and the only reason we're going to give you is we want it that way. We want them to be unequal in their choices and their freedoms, because we think we should have the right to commit adultery, to commit fornication, to commit sodomy, and that the state should have no basis for intruding into our lives, but we don't want those people over there to have the same right.
I mean, you can put it that way, but society, in a lot of its laws, makes these moral judgments. You can make it sound very puritanical, but the laws against bigamy. I mean, who are you to tell me that I can't have more than one wife? You blue-nosed bigot. Sure, you can make it sound that way, but these are laws dealing with public morality. They've always been on the book. Nobody has ever thought they're unconstitutional simply because there are moral perceptions behind them. Why is this different from bigamy?
First of all, the first law that's appeared on the books in the states of this country that singles out only same-sex sodomy appeared in the 60s and 70s, and it does not go way back, this kind of discrimination. Now, bigamy involves protection of an institution that the state creates for its own purposes, and there are all sorts of potential justifications about the need to protect the institution of marriage that are different in kind from the justifications that could be offered here involving merely a criminal statute that says we're going to regulate these people's behaviors through the criminal law, which is where the most heightened form of equal protection analysis ought to apply. This case is very much like McLaughlin, Your Honor, where you had a statute that said we're going to give an especially heightened penalty to cohabitation, but only when it involves a white person with a black person. That interracial cohabitation is different. And the state there made the argument we're merely regulating a particular form of conduct, and that's a different form of conduct than intraracial cohabitation. And this court very clearly said, no, you're classifying people. It's not, and that classification has to be justified. And this court has many times said a mere disapproval of one group of people, whether it be the hippie communes in Moreno or the mentally retarded in Cleburne, or indeed gay people.
Almost all laws are based on disapproval of either some people or some sort of conduct. And that's why people legislate.
And what this court does under the Equal Protection Clause is stand as a bulwark against arbitrary government when there is no rational justification for the line that's drawn.
In order to win under an equal protection argument, do you have to apply some sort of heightened scrutiny?
We certainly do not think we do, Your Honor. We think that this fails rational basis scrutiny, just as the law did in Romer, in Cleburne, in Moreno, in Eisenstadt. All of those laws were thrown out under rational basis scrutiny because the state basically didn't come up with anything other than we want it that way. We want these people to be excluded. We have distaste for them. We disapprove of them. It's mere disapproval or hostility, however historically based, is not sufficient. And certainly even applying the rational basis.
We said the opposite in Bowers, didn't we? I mean, you were asking us to overrule Bowers, essentially, on that point.
Well, certainly Bowers was not an equal protection case and didn't involve this kind of discrimination.
Equal protection and on to the...
No, I was still talking about the level of scrutiny under equal protection, Your Honor.
You're going to hold up one hand, so I'll know which...
It's hard when you have these 2 points to shift back and forth.
I understand. We had the same problem in the last case.
3 weeks ago, yes, Your Honor. But the court, in applying even the rational basis standard, has not been insensitive to the reality of what the world is like and to the fact that some classifications tend to be involving minorities that have histories of discrimination against them, and that the overall effect of some line drawing can be very harmful. In Romer itself, the court looked at the actual effects of the amendment in the Constitution and all of the many ways in which it caused harm. Here you have a statute that, while it purports just to regulate sexual behavior, has all sorts of collateral effects on people. People in the states which still regulate sodomy, every day they're denied visitation to their own children, they're denied custody of children, they're denied public employment, they're denied private employment because they're labeled as criminals criminals merely because they've been identified as homosexuals. And that we submit.
If you prevail, Mr. Smith, and this law is struck down, do you think that would also mean that a state could not prefer heterosexuals to homosexuals to teach kindergarten?
I think the issue of preference in the educational context would involve very different criteria, Your Honor, and very different considerations. The state would have to come in with some sort of a justification.
Justification is the same that's alluded to here: disapproval of homosexuality.
Well, I think it would be highly problematic, such a justification, if that were the only justification that could be offered. If there was not some showing that there would be any more concrete harm to the children in the school.
Only that the children might be induced to follow the path of homosexuality, and that would not be enough.
I think the state has to have a greater justification for its discrimination than we prefer pushing people toward heterosexuality. That amounts to the same thing as disapproval of people's choices in this area, and there has to be a more reasoned and justifiable distinction than simply we prefer this group of people, the majority, instead of this group of people, the minority. Justice Jackson in the Railway Express case said very eloquently that the Equal Protection Clause is an important bulwark against arbitrary government because it's there to make sure that legislators don't avoid political retribution by imposing onerous burdens only on one minority, but that, in fact, the majority will live by the same rules it purports to impose on everybody else.
Mr. Smith, before you continue down to the equal protection line, your first argument was the right of personal privacy in one's most intimate sexual relations. You were asked, and you didn't get a chance to answer because you're back on your equal protection track, you are asking the court to overrule Bowers against Hardwick. I thought that was very
Yes, Your Honor. We are asking you to overrule it, and we think that the right of the fundamental right of unmarried people to make these choices about private adult consensual intimacy applies for different sex couples as well as same-sex couples, and that Bowers was wrong for essentially three reasons. First, it posed the question too narrowly by focusing just on homosexual sodomy, which is just one of the moral choices that couples ought to have, that people ought to have available to them. And second, in its analysis of history, which I think I explained already. And third, and perhaps most importantly, in the assumptions that the court made in 1986 about the realities of gay lives and gay relationships. The court simply asserted in the Bowers case that there's no showing that has been demonstrated between the opportunity to engage in this conduct and family. And certainly, while it may not have been shown in that case or even apparent to the court in 1986, I submit it has to be apparent to the court now that there are gay families, that family relationships are established, that there are hundreds of thousands of people registered in the census, in the 2000 census, who have formed gay families, gay partnerships, many of them raising children, and that for those people, the opportunity to engage in sexual expression as they will in the privacy of their own homes performs much the same function that it does in the marital context, that you can't protect one without the other, that it doesn't make sense to draw a line there, and that you should protect it for everyone, that this is a fundamental matter of American values. So those are the three reasons we do ask you to overrule Bowers v. Hardwick as to the fundamental rights aspect of the case, and we think that is an area where the court should go back and reconsider itself. The court has now left open for nearly 30 years the question of whether anybody outside has a privacy right to engage in consensual sexual intimacy in the privacy of their home. And I submit to you, while the court has left that unanswered, the American people have moved on to the point where that right is taken for granted for everyone. Most Americans would be shocked to find out that their decision to engage in sexual intimacy with another person in their own home might lead to a knock on the door, as occurred here, and a criminal prosecution. And that reality is something the court needs to take into account. And certainly in so doing, it shouldn't, in constructing its fundamental rights edifice, draw distinctions between gay couples and other couples.
You'd probably say the same about adultery. Do you think adultery laws are unconstitutional?
I think that the state has
I think people probably feel the same way about that, It may not be a nice thing to do, but I certainly don't expect to knock on the door and go to jail for it.
Your Honor, adultery is a very different case. It involves the state interest in protecting the marital contract which people voluntarily take on. And so in assessing,
Is the marital contract important to the state? Because it's the source of the next generation, right?
sure, the estate.
And you think that there's not some of the same thinking behind the conscious choice of the state to favor heterosexual and marital sex over homosexual sex?
Well, I can understand a law which says we're going to attempt to channel heterosexuals toward marriage by making it illegal for them to have sex without marriage. I can't understand that law under that kind of rationale, which only regulates same-sex couples and says you can't have sex, but everybody else has a right to do that. As for adultery and all of the other parade of horribles which people have raised in their briefs, it seems to me you've got to look at the individual interests and the state interests, and they're dramatically different in all of those cases. Incest, prostitution, all of these bestiality, all of these things. Either there's very little individual interest or there's very heightened state interest or both in all of those cases. So the idea that by recognizing the right of all adult couples to make choices like this in their own home, the court is going to open up a whole can of worms, I submit, is incorrect. If I could reserve the balance of my time, Your Honor.
Very well, Mr. Smith.